Stewart versus GB Mall Limited Partnership, number 155, September term 2022. Whenever you're ready.
Good morning. If it please the court, Mason Nelson, excuse me, on behalf of the citizen appellants. This is a land use case with a wrinkle. This court has considered countless cases coming from Prince George's County. Classically, we're confronting the actions of the district council.
Mr. Nelson, could you speak up a little bit, please? Thank you.
Okay. This is a land use case arising in Prince George's County. This court has considered many Prince George's County cases. Traditionally, we're arguing about the role or the actions of the district council or the planning board or the zoning hearing examiner. In this case, there's another agency, the Department of Permits of Inspections and Enforcement. We call it DPI. The decision at issue in this case is a decision by DPI to issue a Stormwater Concept Plan approval. 5 or 7 years ago, in my land use practice, I started counseling my clients to look at these stormwater plans. We viewed that these were plans that were being approved without adequate diligence, and so we started raising this issue before the planning board. And traditionally, the planning board would say things to the effect, Nelson, this is not an issue for the planning board. We take at face value the decisions of DPI. We then considered whether we could appeal a decision by DPI to approve such a plan to the Prince George's County Board of Appeals. Did that. In that case, the county argued, no, there's no mechanism in the ordinance to appeal DPI's approval of a stormwater plan to the Board of Appeals. And although I'm an advocate for my clients, I reached the judgment that the county's argument, it was correct, that there was no mechanism in the ordinance to appeal a DPI approval to the Board of Appeals. So,
but a property owner does have that right.
Without one exception. So, that's one of the ironies. An applicant for a stormwater plan who's denied may appeal to the Board of Appeals, but a citizen who opposes the grant of a stormwater plan may not. Yes. To the Board of Appeals. The court's done some hard reading there.
I'm sorry?
I said the court's done some close reading on that ordinance. Yeah, that's correct. I agree with the court on that point. All right, but that left us with administrative mandamus 7400, which provides that if a statute does not authorize an administrative appeal or judicial review action, and if there's a quasi-judicial decision, a citizen can go into court to file a petition for judicial review under 400 rules, which is what.
But the administrative mandamus, the cases say that in order to invoke administrative mandamus, administrative decision has to be final. Is this approval of the conceptual site plan a final decision under the admittedly somewhat sparse case law as to what finality means in this context? The cases say that finality occurs when there is no further action required by the administrative agency. And then there's a carve-out for that, as I understand the law, for administrative decisions that have the effect of being injunctions if they were issued by a court. How does this case, in this context of a conceptual site plan, conceptual stormwater management plan approval, fit into that finality requirement? Or do you say that the finality requirement is no longer the law?
No, the finality requirement certainly is the law. The court summary of jurisprudence I agree with the question in this table, in this case.
Is this a final decision by the department?
Yes, for the reason that if we look at the appendix to the reply brief, we cite 27-282, which are the submittal requirements for a detailed site plan. So this is one of the required findings for a detailed site plan. 27-282E, subpart 11. The applicant must submit an approved stormwater management concept plan. Must submit an approved stormwater management concept plan. So for purposes of the detailed site plan, it is a final judgment. Because without it, final appealable decision, without it, the planning board could not approve, and subsequently the district council could not approve a detailed site plan because it's a fundamental required finding for such a plan.
Sure, the planning board or the district council has the right to say, before the planning board proceeds with detailed site plan approval, you need to have conceptual stormwater management approval. So that box is, at least in this case, was checked. Then you have the issue is, okay, does the conceptual site plan approval necessarily mean that you will get I'm getting my permanent pass. Let me back up, I'm sorry. That you have a conceptual stormwater management plan approval does not necessarily mean that you will get a final approval. That, at least by my reading of the county regulations, is a different step. And so to carry it through, what would happen if a detailed site plan approval has been approved, but then when the developer goes to actually get the building permit, which is of course the last step you would need, then at that point, that's where the failure to obtain a final stormwater management plan or surface water management plan now would come into effect.
I disagree. I understand the point the court is making. So we have two parallel tracks. Stormwater, we're at the conceptual stormwater plan. This is my adversary's argument. It's not a final stormwater plan because there's another final plan down the road, and we're at the first phase. I agree with that factual assertion. But over here, we're in the land use phase. We're at the detailed site plan, which is the final development plan, which has a requirement for the submission of an approved stormwater concept plan. There's no ambiguity about that. You must submit it, and if it's not submitted, you don't get it, and if it is submitted, you've satisfied a requirement. And then now imagine being in my client's shoes with a detailed site plan. We say to the planning board, we want to argue the stormwater concept plan. They say, take it up with DPI. We're just going to check the box. You have it. And once I lose the opportunity to litigate that question before the planning board or the district council, the detailed site plan, that ship has sailed. So if we were to take the court's recitation of the facts to its logical conclusion, what it means is the decision to approve a preliminary conceptual stormwater concept plan by DPI, which is the fundamental bedrock of a detailed site plan, that is manifestly unreviewable on the recitation as presented by this court. We say no. We say that for purposes of the detailed site plan, this is a final order which the court should permit citizens or a losing party to challenge by judicial review. We've tried it before the planning board. They say, we're not going to consider your arguments. We've tried it before the Board of Appeals. They say, we're not going to consider your arguments. So now we're at the administrative mandamus 7400. It's a quasi-judicial decision.
We understand, Hal. We understand the subtitle 7 rules. Look, can I shift gears for a moment? You filed as I understand the record, you filed an appeal from now I'm back on the site plan approval process. And I'm sorry, Council, the act, I get confused over the acronyms.
But I'm sympathetic.
The latest planning board decision on the site plan review and approval process. You appealed, as I understand the record, you didn't file judicial review, you took the option of going to the district council. Is that correct? Or am I misreading the record?
I'm hesitating only because there's so many cases, it's a bit of a blur, but my memory is, if the court's talking about the detailed site plan, it went planning board, district council, circuit court.
So the district council affirmed the planning board decision?
Correct.
And that's in circuit court now?
Correct.
Without a final, if there had been a final judgment issued in the circuit court proceeding, you'd tell us.
Correct.
Pending.
I believe that case was on the docket for last week and was pulled out at the court's request for reasons I don't understand. There was some administrative issue, but no, there's no, it's brief but not decided.
Is the issue regarding the problem with the stormwater management plan, was that raised in the appeal to the district council?
We appealed the district council decision. The focus for tactical reasons in the circuit court was on the question of conformance or not with the applicable master plan.
All right, so, okay.
But I understand the court's question. But tactically, we decided, we can't fight every issue in every case. That was the issue we picked to focus on. So I have a few minutes remaining, but to summarize, a conceptual site plan, even though it's conceptual, is a required finding for a detailed site plan. Conceptual stormwater plan is a required finding for a detailed site plan. And if we don't have the right to challenge it by judicial review, it's essentially, we assert, unreviewable. And I'll follow up on those points in my remaining 8 minutes. Thank you for the court's attention.
Thank you, counsel.
Thank you.
May I have one?
Yes.
One last thing for you to think about and address on rebuttal. Does the property owner, under the current statute, have the right to appeal the denial of a conceptual stormwater management plan denial to the Board of Appeals? You don't have to answer that now, but I'm going to ask your colleague that as soon as he stands up.
I believe the answer is yes.
And so be prepared.
Mr. Tedesco?
Mr. Nelson's a bit taller than me. Good morning, and may it please the court. For the record, Matthew Tedesco with co-counsel Gregory Hislop, here on behalf of GB Mall Limited Partnership. My client is the owner of the Beltway Plaza Shopping Mall located in Greenbelt, Prince George's County, Maryland. And we are before you in response to the circuit court's granting of our motion to dismiss Mr. Nelson's petition for judicial review under 7401 or 7400 mandamus of the approval, the DPI's approval of our conceptual stormwater management plan. First and foremost, I just want to hit on one thing from the argument that we just heard. Opposing counsels, as is often the case, and Mr. Nelson and I spar regularly, but opposing counsel's attempt at obfuscation is as deliberate as it is incorrect here this morning. There was a lot of mention to the detailed site plan. And the reason for that, Your Honors, as this court is all too familiar with, is because this court has already adjudicated the preliminary plan of subdivision that Mr. Nelson appealed in this matter, favorably to the planning board's decision on that subdivision plan. As part of that subdivision plan, the planning board is required to make a finding with respect to the preliminary plan of subdivision demonstrating adequate controls of the increased runoff due to 10-year stormwater or such other standards as state and county law shall adopt. In other words, it's the preliminary plan of subdivision for which the planning board makes a determination that the stormwater concept plan and what's proposed at that phase of development is appropriate to make that finding. Mr. Nelson is very seasoned, very experienced, at any time could raise that if he's not feeling that.
But in the planning board's decision on the preliminary site plan, I'm sorry, the preliminary subdivision approval, thank you, counsel. Didn't the planning board direct the Department of Permits, Inspections, and whatever the E is, to submit a new concept plan because there was some sort of
Correct.
There was some sort of defect in the plan that was presented to the board as part of the subdivision approval process.
That's correct. The planning board made a finding in the preliminary plan which this court affirmed, and the Court of Appeals.
Well, it wasn't raised. This particular issue wasn't raised.
It wasn't raised.
If it's the if we're talking about the iteration of the case that I wrote the opinion about a year or so ago, I don't recall that issue being raised.
It's not raised, and that's to the point. That's the point I'm trying to make, Your Honor, is that it's not raised. And what Mr. Nelson's trying to do here is collaterally attack something midstream because it wasn't raised when it should have been raised. And he's, again, trying to bootstrap that argument with the detailed site plan, for which it's not appropriate at that point.
How could he have raised it in the judicial review proceeding on the for the subdivision approval when the planning board directed the department to reconsider it and issue a new permit?
So the issue there, Your Honor, and I don't want to confuse the facts here, but the issue there is that the planning board made a finding that stormwater adequacy pursuant to 24-130 B1 was met. The requirement, however, of the planning board was because these plans evolve, just like the conceptual stormwater plan evolves to ultimately a technical final stormwater concept plan, which has been approved in this case, making this hearing and these proceedings moot. I do want to hit on that issue in a moment. But nevertheless, the planning board in approving and making that finding determined that stormwater concept has been approved pursuant to the requirements of the county law and the stormwater manual, and that in order for, at the time of detailed site plan, because again, the detailed site plan, or the preliminary plan doesn't approve development per se, it approves development subject to adequacy tests, as well as subdivision of land. The detailed site plan is what approves what's actually going to be built. So that's why the condition that Mr. Nelson cites here is that there has to be an approved plan at the time of DSP.
Isn't it more accurate to say that the detailed site plan outlines and prescribes what eventually the developer or the property owner will be able to seek building permits on?
Yes, all roads lead to a permit approval.
But it doesn't lead inexorably to permit approval because there could be some sort of glitch at the building permit.
There could be a glitch at the building permit. There could be a condition at the time of detailed site plan that requires the applicant to redesign something. That redesign in and of itself will require a redesign of the stormwater concept plan. That's why it's not a final decision.
Well, I understand why. Well, let's talk about finality of the stormwater management plan for a second. Okay. Does a property owner the property owner has the right under the county's zoning ordinance, under the county code, to appeal from a denial of a stormwater management plan?
Correct.
Does that extend to the right to appeal to the Board of Appeals the denial of a conceptual stormwater management plan?
No.
Okay. Is that based on the wording of the statute, or is there case law on that?
No, it's based upon the fact that the stormwater concept plan is denied, then the applicant, it's denied presumably because it's not conforming with the technical manual that's required for stormwater. So the applicant would basically be able to amend that plan to seek the approval. If it's denied based upon meeting all the requirements, then yes, you could take that to the Board of Appeals. But it gives the applicants an opportunity, because it's a conceptual plan, going through the process to get that approved. If it's not approved, then there is appellate rights to the Board of Appeals. However, I've never seen that in 18 years, because what often happens is those plans are amended and revised, going through the permitting process, you get to the third step, which is the final technical stormwater approval. That approval, and I'm not here to tell Mr. Nelson what plans and what approvals should or should not be appealable. That's his job to figure out. But it's certainly not the concept. If anything, it's the final approved plan, because that's the plan that releases the ability to get a fine grading permit to actually construct the facilities conceptually approved years before. And that's why I submit before you today that this hearing is moot on its face, because those final stormwater concept and erosion and sediment control plans have been approved. So if this court engages in Mr. Nelson's attempt to rewrite law and try to collaterally attack a stream of approvals at the very first step, right? Because you look at the definition of stormwater concept plan defined in the article, in subtitle 32, which we've briefed, it specifically, it's section 32-171A14, the concept plan, the first of 3 required plan approvals that includes the information necessary to allow an initial evaluation of a proposed project. That's in the definition of a concept plan. It's in the name, Your Honors, concept. So, to the point, if we come now and allow the court to intervene and interject into a stream of approvals and review that has already occurred with technical approval, the final step.
But you've just said that the statute permits the County Board of Appeals to intervene in that if the concept plan is not to the owner's satisfaction, right?
It's limited to the applicant, Your Honor.
Yeah, but why should it be limited to the applicant? If it is flawed from the applicant's perspective, the applicant can have the right to appeal. Okay, but if it is flawed from a neighbor's perspective, the neighbor does not.
The neighbor would have the ability to appeal that at the time of either the preliminary plan of subdivision, because it's an element of the preliminary plan of subdivision pursuant to the required finding, or they would have the ability to seek a mandamus appeal like Mr. Nelson's attempting to do at the time of final. The third and final step, because that's the final decision. The concept on itself, by its own definition, is the initial evaluation. I don't know of a concept plan ever being denied, because they don't get denied. What happens is that with DPI get your initial plan and they say you need to do X, Y, and Z.
You do X, Y, and Z.
You can't move forward. I can't get my preliminary plan accepted. I can't get my detailed site plan accepted. So I've never seen, and as I stand before you, I can't cite to the code section of subtitle 32 that actually says it, but I've never had a stormwater concept. I don't know of a stormwater concept plan that's been denied because it's an initial plan. And it changes. They almost always change.
When I was in private practice, I certainly represented several agencies that were in the stormwater management permit granting process. And it's, if the granting agency wanted something done, it was done.
Correct.
But I digress here. Go ahead.
And it's done per the technical manual. But I would submit before you that this is moot, and this court, we believe, must dismiss this appeal, otherwise risk the risk of abstract disagreement, which would allow the judicial interference that would unreasonably entangle the reviewing court with the agency's already approved final technical stormwater plan that was never challenged or appealed. Now, getting to Your Honor's other point, we also we believe that the circuit court's dismissal of Mr. Nelson's petition for judicial review was proper, because this was not a quasi-judicial proceeding, the stormwater concept approval. The law is very clear that the steps for quasi-judicial must entail a contested process, where testimony is taken, fact-finding and weighing of evidence occurs, credibility and determinations are made, and a final decision is issued. We've cited in our brief section 32-182 of the county code, which provides the process for stormwater concept approval. It does not meet the elements of a quasi-judicial proceeding, and therefore the mandamus petition was properly dismissed. Now, turning to Judge Kehoe's question with respect to finality, we also do not believe, notwithstanding the mootness of this proceeding, that we believe that the dismissal was proper because the Stormwater Concept Plan approval constituted only an initial, non-final component in a comprehensive three-step process. As I mentioned previously, the definition of a concept plan under section 32-171A14 of the county code is that it's the first of a three-step required plan approval process that includes information necessary to merely allow the initial evaluation of the proposed project. Once the concept's approved, then you go to the second step, which is the site development plan, section 32-182B. That definition, 32-182B, outlines the procedures with respect to the second step, which has also already occurred in this case. But 32-171A60 is the definition of a site development plan, and that is defined as the second of three required plan approvals that includes the information necessary to allow a detailed evaluation of the proposed project. After that, you go to the third step, which is 32-182C, D, and E. That's the final step that leads to the ultimate issuance of a fine grading permit. To get that fine grading permit, you not only need your third and final step of a final site development concept plan, but you also need the preliminary plan of subdivision approved, you need your detailed site plan approved, you need your record plots approved, you need all the approvals in place from the administrative agency. At any point, Mr. Nelson could raise these issues at any one of those approvals, albeit I will stand before you that the appropriate one is during the subdivision case, which he failed to do.
Counsel, it's my understanding that the final stormwater management plan has been approved by the department?
Yes, sir.
Is there a pending judicial challenge to that?
No, sir. That's beyond appeal.
Or to the Board of Appeals?
No, sir. No, Your Honor.
What was the date of that?
The technical fine grading stormwater plan was approved, I believe, the end of June, early July, and the erosion sediment control plan was approved in July of this year, 2022.
So that's not in the record then?
It's not in the, well, there is no record here. This is de novo because it's only, we never had a hearing on the merits because it was dismissed. Mr. Nelson's petition for judicial review was dismissed. So we're here on that motion, on the grant of the motion to dismiss. So there's no record. So just going through I'll conclude with that because it is final and no appeal was ever raised and it's beyond appeal at this point. I did want to spend a quick minute just clarifying this court's decision in CREG Westport, which was a purported opinion from this case that we relied upon in our papers at the circuit court, support of the motion to dismiss. The Court of Appeals this year reversed that decision on a very narrow technicality with respect to that particular case. We believe the holding of this case, or the reasoning, I should say, for the holding of the CREG case is still applicable, notwithstanding the Court of Appeals' reversal of that, and we did brief that. And just very quickly, the Court of Appeals really, the only reason the Court of Appeals reversed this court's reported opinion in CREG Westport 1, which was 252 Maryland at 470, was because that was an appeal, a collateral attack of appeal of the Forest Conservation Plan, again, another element of all these entitlement plans, that was appealed piecemeal. And what the Court of Appeals says, because the Forest Act, the article of the code, specifically required a separate appeal process for that particular plan, and the county adopted such implementation of that, there was the ability to appeal that separate and apart from these other entitlements. There were some dissenting opinions of that at the Court of Appeals, but I will tell you that that's distinguishable from this case because there is no statutory requirement either at the state level or at the county level implementing the state's requirements for stormwater concept that calls out such a specific appeal right to appeal the stormwater plan separately. That's why Mr. Nelson is filing it under the mandamus principles, and I submit before you that if there were such a statute or provision, Mr. Nelson would have jumped all over it in the reply brief.
Sure he would have.
So it's not there, and that's a distinguishing factor between the case. Between that case and this case, but nevertheless, the reasoning of this court, we believe, is still very much sound. Your indulgence, Your Honors. So So as I mentioned, we do not believe that this is a final appealable decision. No grading or construction permits can be approved based solely on the approval of the Stormwater Concept Plan. If the Stormwater Concept Plan is final, as Mr. Nelson is arguing here today, and appealable, there would be no reason for the code to require a final technical stormwater plan or a soil and erosion sediment control plan after the approval of a Stormwater Concept Plan. If the concept is the end-all be-all, we don't need the other 2 or 3 steps. Just because opposing counsel, in an attempt to slow down this development by filing frivolous appeals, which has been customary, would like this Stormwater Concept Plan to be final, it does not make it so in this case. The definition of concept plan on its face alone answers the question and is dispositive of the legal analysis that needs to be done in this case. It's not a final appealable action, and the circuit court's dismissal of it was appropriate. Again, we talked about the other argument we made in our brief was the appellant's ability to challenge this at the preliminary plan stage. They elected not to. It wasn't raised. This court has affirmed that decision, and for that reason, Mr. Nelson is now trying to come in and collaterally attack an element of an overall very technical review process because it wasn't raised previously and has subsequently lost on the appeal of the preliminary plan of subdivision. Your Honors, in my closing minute, I just want to ask you to think practically. It's a concept plan. They almost always change. They have to, because as these entitlements and these projects go through the review process, they evolve. They get more technical with each step. You start with planning, zoning, and then entitlements. Ask yourselves, when was the last time any of us drove a concept car home from the car show?
Well, what I'm asking myself is it fair to allow, is it equitable to allow a property owner who is unhappy with a concept plan denial to appeal that to the Board of Appeals, but to tell neighboring property owners if they are concerned about the wisdom of a grant of a concept plan, a stormwater management plan, they're out of luck. There's a clear, to me at least, clear dichotomy in treatment of the 2 categories of parties that is not necessarily dispositive, but which is troubling.
Well, let me, since I had a moment to go back through, I don't believe there is a statutory provision that allows for the appeal of the denial of a stormwater concept plan in subtitle 32. I think if I were to elect, so I may have to correct myself on that, I do not believe there's a statutory provision that allows me to appeal that directly to the Board of Appeals. I misspoke on that. I thought that there was, but I've not been able to find one in my review of the record while I've been sitting here. Mr. Nelson has a citation. I'm happy to be corrected, but I don't believe there actually is a specific section in subtitle 2032 outside of a denial of a permit or outside of a violation. So I don't believe that there, Your Honor, I will correct myself, I don't believe that there is a separate one. If I felt aggrieved from the inability to get a stormwater concept plan approved, I could file a mandamus action in circuit court or some type of injunctive relief. But I don't believe that I have even the right to go to the Board of Appeals because they're not denied. They're not structured or designed in the code to even be denied. You have to comply to get it approved.
Well, after hearing from your colleague on this, this would not be perhaps the appropriate thing would be to direct the parties to file something in writing post-argument specifically on this issue. But we'll cross that bridge if we come to it.
Would be happy to. I believe we cited it in our brief that what the appeal rights are under the subtitle 32.
You have, yes.
Yeah. Thank you, Your Honor.
Mr. Nelson, you have 8 minutes. If you could start your argument by addressing the mootness argument, that this appeal is moot.
The case we assert is not moot. The one of the required findings for a detailed site plan was a conceptual site plan. In response, my adversary says Nelson should have raised it before the preliminary plan of subdivision. We did.
But do you agree that their final stormwater plan has been approved and there's no appeal from that?
I know that I haven't noted an appeal of any final plan.
Has there been one approved?
I don't know whether there has or has not.
If there has been, what could we do at this point?
We assert this court has jurisdiction to hear this judicial review action to consider the petition for judicial review regarding the Stormwater Concept Plan approval. We raised it before the planning board. The planning board said, raise that at the
It's already been decided. We normally don't consider moot issues, and if this has already been finalized, what could we do at this point and say about the concept when the final plan has been approved?
My adversaries argued that there's a final stormwater plan that was approved. Maybe there was, maybe there wasn't. I don't know. It's not in this record. What we're challenging is the stormwater concept approval.
If he's correct, though, would your appeal be moot?
I don't think so.
So do you agree that a mootness question, if there's nothing we can do, that an issue is moot?
I beg your pardon?
If there's nothing no remedy that we can provide, do you agree that that means an issue is moot?
I didn't mean to speak over the court. I think there is a remedy. The remedy is to allow my client to have a hearing on the judicial review action to give respect to what the chairman of the planning board said, which is any appeal of the Stormwater Concept Plan approval should go to DPI. That's in the extract at 49. Any appeal of the concept plan, Betty Hewlett said, would fall within the purview of DPI.
If there's already been a final plan approved, what remedy could we give when, the concept plan is step 1, a final review is step 3. If step 3 has been satisfied, what benefit would you get by review of step 1?
All right, well, think of a preliminary plan of subdivision and land use process. Think of the detailed site plan. Let's assume in every case, the cases are moving down the track. You have a preliminary plan approval. It's in play. You have a detailed site plan approval. Let's say that's affirmed. You can still challenge the preliminary plan, even though it's lower in the hierarchy. It's not the final plan. But the question is whether there was a legal error, and we assert there was, that contributed to that decision. So I think that
You're talking about, I think, from my perspective, two related but separate things. Challenging the decision by the substantive decision on the detailed site plan approval, because there's a flaw in the detailed, in the conceptual stormwater management approval, or challenging the conceptual stormwater management plan approval as a separate concept. And as I understand, Judge Graf's concern is on the stormwater management plan track, we've moved beyond it because there is now a final administrative adjudication. Doesn't that render moot the conceptual challenge?
no, because there are different considerations applicable to each grant of each phase of the permitting. But consider from my client's perspective. We go to the planning board, we raise this issue. They said, Nelson, it's a detailed site plan. We go to the detailed site plan, they say, Nelson, take it up with DPI. We appealed the Board of Appeals. They said, no right to appeal, and we will submit a brief on this. I've written it in another case. Under the ordinance, only a losing applicant can appeal a stormwater plan. A citizen cannot. I'll brief that point in response to any request from this court. So then we do administrative mandamus. And now they argue, oh, well, you didn't appeal the final plan. How many appeals must we take? How many appeals must we? We've been trying to preserve this issue for 3 years. How many appeals must we take?
Maybe only one, maybe from the final plan.
Well, I disagree with the court, because this is how the land use review process, when you're challenging a plan, detailed site plan, for example, there are required findings. These are like the elements of the case. The applicant presents evidence of the elements of the required findings. The citizens challenge those. The agency makes a decision. One of the required findings was a stormwater concept plan approval. And we were prohibited from challenging that in the planning board, prohibited from challenging that in the Board of Appeals, and prohibited, up to now, from challenging that in the circuit court. So, to answer your Honor's question about, well, why is it a moot? I mean, can anyone in this room recite the required findings for a stormwater concept plan versus a final concept plan? We'd have to look at that. They're different. So I would urge this court to reverse the decision of the circuit court for the following reasons. First,
Hold on, before you summarize, what specific aspects of the conceptual site plan, of the conceptual stormwater management plan, do you think were objectionable?
I didn't prep that for this argument because we're focusing on the final judgment issue, the ability to file the petition for judicial review. We'd have to go to the transcript, which is in the record. We had a a stormwater engineer testify about the stormwater concept plan approval. It's all in the record. We had an expert witness, which they wouldn't hear from. So it's not relevant. So I haven't mastered those facts for this case because they weren't central to this legal argument.
Well, then what you're saying is at least one of the issues you would raise is that the department refused to consider the testimony of your expert witness. Or was that the planning board refused to consider it? And then if you can't recall, Mr. Nelson, you can't recall.
Let me just read to you from extract 49. This is the transcript before the planning board on the detailed site plan. And I'm pressing this point about the stormwater. And this is what the resolution says.
Extract page 49 in my extract is the page in the board's detailed site plan approval that discusses paragraph 8 that discusses the stormwater management issue.
Right, so, and it's the second half of that paragraph. Testimony was heard from experts on behalf of both project opponents and the applicant concerning stormwater facility design and functionality. The planning board noted, however, that the stormwater analysis is undertaken at the time of preliminary plan of subdivision, not DSP, and a finding was made at that time that the existence of the approved stormwater concept plan met the requirements. Further evaluation, etc. So what they're saying there is, we're not going to look at it here. And then in the detailed site plan, bear with me. In the planning board, this is appendix 013-14. In the planning board, in the preliminary plan of subdivision, the planning board said, we will consider it the detailed site plan. So I summarize with these thoughts.
You are out of time. If any of the judges have further questions, otherwise you are out of your time.
Thank you so much for the court's attention. It's
Thank you. Thank you both.